Oh, sure. I think maybe we did already talk about it a little bit. All right, we're live. Okay, this is Senate Natural Resources and Energy, and it is Thursday, April 24th. And we are starting the morning out with a bit of history about the appeals process, both, I think mostly Act 250, but also maybe a little bit about municipal appeals. So, and we've got our Ledge Council here with us. Welcome.
Thank you. Ellen Tchaikovsky, Office of Legislative Counsel. So I have been working on Act 250 for about 6, 7, 8 years. So I had to go back and look at some reference materials. There's some great history in the Commission on Act 250 the Next 50 Years report on the history of appeals. Because the commission there looked at how appeals were originally handled when Act 250 was passed and how they have changed. So when Act 250 was passed in 1970, permits approved by district commissions, appeals of those permits as well as the jurisdictional opinions would go to the environmental board. And that process, it remained that process until 2005, when the legislature moved the appeals from the board to the environmental court, where they have been for the last 20 years. When the appeals went to the board, it was a slightly less formal process. They did use the rules of civil procedure and evidence, but they weren't strictly enforced. And so the board had flexibility on how they would interact with the parties. It was considered a fairly citizen-friendly process based on what I have heard. I was not there. But the court has a much more strict set of rules and formalities that it follows. The board did not allow any formal discovery. They could compel documents to be produced or compel witnesses to testify, but otherwise most of the work that was happening at the appeal at the board was people submitting their list of issues, the summary of the complaint, what criteria they were concerned about, and then they would sometimes bring witnesses who were experts. And so they would have pre-filed testimony where they would provide what they were an expert on and their review of the site and issues, and then they would bring that to the hearing where they would put on the witness and review their testimony. And so it was a process where people could not necessarily need to hire an attorney. They could represent themselves, which is still true of the district commission process, but a lot less true of appeals that go to the environmental division of the court.
Pause for a second. Something I neglected to say is that the reason that we are talking about this is because there's a housing bill and economic development that's likely to come to us. And it has some language around appeals. So having this context, I think is going to be important for making some good decisions about what we do with that.
This is good. I have read it. I don't have it all found.
I've read it multiple times. I wrote part of it, so I reference it multiple times. There was a copy in this room for a long time, but it's not here. Sorry, it's digital too. I think that you didn't.
Thank you. I just want to make sure I said that. Sorry, please, Karen.
No, that's great, because another element I did want to mention that's more relevant to what you're going to be looking at is initially when Act 250 was passed. There was a requirement that there be notification of an application sent to a specific list of people. It was the adjoiner, the regional planning commission, the municipality, and it was a pretty short list, but those were the only people who could participate as parties and who could therefore appeal. Over time, who has had the ability to appeal has changed. So beyond the list of people who get notification, now any person can attend the district commission hearing and request to be given party status. In order to be given party status, they have to identify a specific criteria of Act 250 under which they have been impacted. So they have to identify a particularized interest that would be injured under one of the criteria. They can claim all 10, but I think it's not as common for people to do that. They identify, aesthetics is a pretty common one. My aesthetic view is going to be impacted by this project. I'm seeking party status for criterion 8. Or there's going to be runoff from this project. I'm seeking party status under criterion 1 for potential impact on my property from runoff. And so the district commission will make a decision on whether or not they've had enough demonstration of evidence that they meet the requirement to get party status. They do that review initially at the beginning of the process when they ask for it, and they also review it at the end of the process to see if they actually met their burden of demonstration. The only people who can appeal then to the environmental division is someone who has maintained their party status. If they lose it, they can appeal that decision to the court, but otherwise no other person can appeal. And what this does require is that they have to have been participating at the hearing and during the process. So there's a participation requirement, and the participation requirement was added later in Act 250. I think it was added in the early to mid 2000s. And so that was something that had come up about people coming out of nowhere to appeal a project. And so this does require people have participated and have kept their party status throughout and made demonstration that they are going to be injured. And so that is one of the differences with the current municipal permit appeals. So municipal zoning is a system that is similar to Act 250, but has a number of differences. Municipal zoning is administered at the local level if and only if the municipality has adopted a town plan and adopted bylaws to implement their town plan. The municipality generally will have appointed a zoning administrator, an administrative officer, who is in charge of reviewing applications and issuing decisions on applications. Municipalities also have the ability to decide, they also will have an appropriate municipal panel. It may be called the Board of Adjustment or the Development Review Board. There's a few different structures they can have, but generally we refer to them as the appropriate municipal panel. And so towns also have the ability to determine if that board itself should be reviewing some of the applications. So a lot of times the more simple applications will be reviewed by the zoning administrator, more complex ones will be reviewed by the panel itself. And so decisions of the zoning administrator are appealed to the panel. If the panel has reviewed it, there can be an appeal taken of that decision again to the panel. There is a requirement that there be finality in the decision of the panel before it can be appealed any further. And so,
Sorry. It can be appealed to the panel. Can you just say one more time who the panel is?
yeah, so it takes different structure, there's different structures in different towns. We call them generally the appropriate municipal panel. It's either the Board of Adjustment, the Board of the Development Review Board, or there's another name that some of them call them.
So we go with registration.
Sure, and some of them do like hybrid planning commissions where they give them also authority, but for general purposes under the chapter, whichever board has been empowered to do review and appeals of permits. That's who we're talking about. So it's the local panel that has been appointed.
Yeah, that's interesting that there's like a generic term for it, because I think we probably all know it by whatever is the appropriate term in our towns, you know, like
Yes.
I'm familiar with like the Development Review Board.
Yeah.
But yeah.
And more towns are moving towards that. Originally, it is partially because the statutes have changed over time. There was the Board of Adjustment. And that's less common now. And so I think a lot of people move towards these development review boards, and it's because of in some ways the complexity of the projects that are coming up and the level of review towns are doing on them.
Yes, go ahead.
So that document you have for me, is that actually the law? Because I was told that it was presented by the committee, but it never really had finality to it.
So the document I was waving around is a report. It's a report, so it is a history, it's history, if there's a narrative portion that, there were 10 tasks for the commission. They did a significant amount of research and data analysis, and so, yes.
Okay.
But the law is the law, it's in the green books, this is a report. So. In order to appeal a permit from the municipal level, there's a different list of people who are allowed to appeal. They're called the interested persons. And so there's 5 different categories of interested persons. And I should probably pull out the exact language, because this is what is at issue in H 479. So the interested persons are people who are allowed to appeal a municipal permit decision. So it's the person owning title of the property or municipality or solid waste management district. It's the municipality that has the plan or bylaw at issue. Number 3 and number 4 are the ones that come up a lot and will be the subject of discussion, which are a person owning or occupying property in the immediate neighborhood of a property that is subject to a decision, who can demonstrate a physical or environmental impact on the person's interest under the criteria of review. And so this is similar, but not the same as under Act 250. So Act 250 requires a particularized interest and an injury under one of the criteria. This is a person in the immediate neighborhood, so there's a location requirement, who can demonstrate a physical or environmental impact. And so that's generally considered a slightly lesser standard than an injury under one of the criteria. And then there's this other category, which is previously was any 10 persons, but is now any 20 persons, who are any combination of voters, residents, or real property owners within the municipality who sign a petition. And there is no injury required for that group of people. This is unusual in standing generally. So what we're talking about here is standing, who has the ability to appeal. And not requiring an injury is unusual to almost any other type of appeal in the other realms. So this is something that has been discussed in the last 3 or 4 years, the legislature, and is addressed in H 479. The last interested person category is any department or administrative subdivision of the state owning property in the town. And ACCD. So these are people who are going to be notified of these projects, but also will have the ability to appeal them. So after so an interested person can appeal to the appropriate municipal panel. Decisions there can be appealed by this list of interested persons. These people have to have participated in the hearing on the permit at issue. They have to have provided either written or oral comments, and the panel is supposed to provide an opportunity for that to happen, so that they can identify who are people that are attempting to become interested persons.
This is the municipal part.
Yep.
They have to have attended and provided, so it's not enough to just attend.
Yep.
You have to have provided written or oral comments.
Yep. Yep. So both Act 250 and municipal has this requirement for participation. Yep. And so from there, both Act 250 and the municipal appeals go to the environmental division of the Superior Court. So the environmental division was created in 1990, and that is when municipal appeals started going to that court. And so the court originally was not hearing Act 250 appeals, those were being heard by the environmental board, and so municipal appeals have been going to the court. I think the whole time, because even before they created the environmental division, I believe they were still going to the civil division. And then appeals from there in both types of permits go to the Supreme Court. So the primary distinction between the two types of appeals is who is allowed to appeal. And who are the panels that are issuing? There are different types of panels. The district commission process are, a group of 3 that are appointed by the governor that sit for that district. It is a citizen-friendly process that it's strictly adhering to the rules of civil procedure. The municipal proceeding is slightly different. They may be hearing multiple cases at a time based on how many permits are being requested. But then above that, they're following the similar appeal process of going to the environmental division, then up to the Supreme Court.
So what this is really doing is eliminating point, so fucking up.
We're gonna get there yet.
Okay.
I'm just doing a history and how appeals work. I'm coming back later to talk about the language.
Yeah, this is just background.
This is back.
Yeah, how we got to where we are.
Okay.
Yes, yeah, good.
You know, we still centralize the boards and commissions, I mean, where are they located? Are they district courts, district boards, commissions? The
For-
people that, the preliminary steps of this process.
For Act 250.
Yes.
Yeah, so there's 9 district commissions in the state. They roughly correlate to counties. Most of them have 2 counties, but Chittenden's by itself. And it is a 3-member panel. They are essentially volunteers who get a per diem payment, $50 a day for when they're holding hearings. But they're appointed by the governor, and then there's a few alternates for each district as well. They are members of that community where the district is located. They do have some staff, so there's a district coordinator for each district, and some of them do have technicians that do the sort of more administrative work with them. But a permit is submitted, it's to that district where the project is going to be located. It's reviewed by the district coordinator for completeness. And then if it's a minor project, there may or may not be any hearing needed. If it's a larger, more complex project, a hearing will be scheduled and then held with the district commission. Depending on the level of interest and issues raised at the first hearing, there may be subsequent hearings. But the district commission has to issue the permit decision within 40 days after the end of the close of the hearing. And yeah.
Regional planning commissions have any involved in it? They review to make sure it meets the regional desire.
Yep, so criterion 10 under Act 250, it asks if the project complies with the regional plan, and so regional planning commissions are given notice of the application and they have the ability to weigh in if they so choose.
So I know you said this, but I need it again. About the appeals, like who hears them.
Mhm.
So for Act 250, it goes to, right now, it goes to the environmental court.
Yeah.
Okay. That I feel like I get. For municipal appeals, it goes to Superior Court? No.
Nope.
You know, I don't know. Who does it go to?
They also go to the environmental.
It also goes to the environment.
Yes. And they have since the environmental court was created. Yep.
Okay. And if it's so from the environmental court, regardless of which path it took to get there, if it's appealed again, then it goes
Is
Supreme Court. Okay. Okay. I think I am there. Thank you. Yes.
So if a municipality, the zoning board or issues a permit for, say, a change of use of a property, can the Act 250 commission trump that? Do they have to have visibility on that? And can they say no? you have to have an active 50.
So it's, I can't give you a yes or no.
Okay.
What happens is, Act 250 has very specific jurisdictional triggers. And so a project may or may not need an Act 250 permit. Primarily it is based on the size of the parcel of the project. So if it's a commercial project, it's based on the size of the project and whether or not it triggers Act 250. If it's town has zoning, if it's located on 10 or more acres, it will trigger Act 250. If the town doesn't have zoning, it's on more than 1 acre. And the reason that is because if the town has zoning, there's a presumption that the town will have oversight and use its zoning to have oversight of the smaller projects. And so Act 250 only needs to have oversight of the larger projects. And so in cases, in smaller towns in the downtown area, there's a lot of times where the Act 250 would not be triggered and just there would just be municipal oversight. But there are times when there are larger projects where a project will need both an Act 250 permit and a municipal permit. And it really just depends on also if the municipality requires, municipalities have the authority to, exempt certain kind of projects from their oversight too. So certain projects may not need any kind of municipal permit. And so something could need an Act 250 permit or a municipal permit or both. And so, yes, there definitely have been instances where a municipality has said, yep, go forward, but Act 250 has said, you have not met the Act 250 requirements.
So in jurisdictional opinions, it used to be that the commission couldn't issue it unless it was requested. Now I think they can issue it on every case, right?
So a jurisdictional opinion is an assessment of whether or not a project needs a permit, and anyone can request a jurisdictional opinion. If someone submits a permit, a district commission could say, oh, you don't need a permit based on our jurisdictional trigger, so you don't need this. They would do the first level review of whether or not it's necessary. Okay.
Great. Any other questions at this point, at least as to the history? Thanks.
Yes, so I will be back to discuss 479.
I do have one more.
Sure, yeah.
Okay, I wanna go back to, in the municipal, I mean, we can obviously talk about this more later.
Yeah.
But, in the municipal section, the 5 categories, the one that was, there was a lot to that. Either third or fourth one, the immediate neighbor. So if you're. Does that mean an abutter, or does it mean literally like, I'm in the neighborhood?
Yes.
Like I'm just close by,
Yes,
it's the close by, not the abutter?
correct.
Is there a test or like a standard for how close is close enough?
There is some case law on it, I don't know it off the top of my head.
Okay,
Yeah,
that's just very, it's curious. It's interesting.
Well, yes, but you could be 2 houses away.
Yeah,
This is a
yeah, right,
life,
yeah, fair enough, yeah,
so you slow it along.
sure,
Yeah.
yes, right, exactly. Okay, thank you. Okay. Okay, so we are gonna have Ellen back. Just as a quirk of our scheduling today, we're gonna switch to 231. We have a new draft. And we have Mr. O'Grady with us to walk us through the new draft of 231.
So that's that.
So how would you like me to proceed?
I think just going through changes, which is the new language.
I don't have any new
Oh, okay,
I
something,
have
yes,
language from the agency.
oh, yes, okay. I probably missed a step and being like, hey, let's incorporate the agency.
Right,
Okay, that's on me. So,
So I can describe what the agency is, the department, I should say, is proposing.
yes, maybe we could do that, and if we have questions about that language,
Sure.
anything you wanna flag for us, that would be great.
Yeah, so remember, or you may not remember, when we did the walkthrough, there was a discussion of a section that had been removed from H 231 in the House at the very last minute. Because it raised concerns about whether or not it reached too far into Second Amendment rights to carry a firearm. Is the way that the language was intended to deal with these new types of weapons that don't use an explosive to propel a projectile, they use compressed air. And it's a weapon of choice for those that are hunting without a license or out of season because it's quiet, they're effective. And so the agency department wants to regulate that, but because of the language that was in H 231 as it came out of House Environment, there were concerns from those who are interested in Second Amendment rights that it went too far. So that language was totally removed from the bill, and the department instead is proposing new language that would focus on the specific types of weapons that they want to regulate, and those would be air rifles, arrow rifles, pre-charged pneumatic rifles, and they would then define what those are. To mean an air rifle is a 22 caliber device that fires a bullet solely by the use of unignited compressed gas. An arrow rifle is a device that fires an arrow or bolt solely by use of unignited compressed gas.
Thank you.
And a pre-charged pneumatic rifle is an air rifle or arrow rifle for which the proton is supplied or introduced by means of the source that is physically separate from the air gun or arrow gun. I don't personally know. I haven't seen that last version. I've seen the other two versions. But these are the things that the department wants to regulate. And they would then amend the law that says a person shall not carry or possess while in or on a vehicle propelled by mechanical power within the right of way any of the following: a rifle, air rifle, arrow rifle, pre-charged pneumatic rifle, or shotgun containing a loaded cartridge or shell in the chamber mechanism or in a magazine or clip within the rifle or shotgun. So that takes away the regulation of the handgun, loaded handgun, with Second Amendment proponents did not want infringed on. And it addresses the department's concerns about people hunting illegally having their weapon charged so that they can take an animal out of season whenever they have the opportunity. Now, I do think that there is a portion.
Yes, so we don't have a new draft.
Oh, we don't.
We're just talking about the language that the department was, so
Oh, I see.
we may,
Okay,
so yeah, nothing new.
okay.
There is a portion of the department's language that it has a cross reference in it that's incorrect. And I need to track that down. It's on page 2 of their language, where it says any vehicle, unless it is uncocked, a person shall not possess or transport a crossbow in or on motor vehicle, boat, air, police, and drill, etc. Except as permitted under subsection 4705E. 4705E is when you're allowed to hunt with paraplegia. And it doesn't really reference carrying of a cocked weapon. So I need to double check with the department on what their intent was with that language. But other than that, I do think the language addresses the issue that arose in the House. I do think there will be some people that are going to be uncomfortable with the existing law that you can carry a rifle or a shotgun with a loaded round in your motor vehicle, that's existing law. And so, be prepared for a little pushback on that, but that's how the law has been for over 30 years.
Do you have something to add?
Just, know, muzzle loader is considered unloaded if the primer cap is out of it.
Yeah,
And part of the reason for that is that if it's during the season, in order to unload the projectile, you have to find some place to shoot it. It might be the same thing with a air rifle if they have like a pneumatic cartridge that
right.
is loaded with propellant. That's the only thing I can think of. It's a safety issue more than anything else.
So for the muzzle loader, it has to have the percussion cap primer battery fixed. It can have being charged with powder, but it has to have that cap or primer attached to it to be considered loaded.
Right, and I'm thinking the same thing, if a pneumatic air rifle has a cartridge, has a canister that
Yeah.
provides the propellant,
Yeah,
if that were removed,
It's not a book, yeah. Can't fire it.
right,
So
so anyway.
are you suggesting that?
I think that because the language says a pre-charged pneumatic rifle. I think that is the concern, that takes out that charge. Compressed canister, it's really kind of I don't even know how, it's not a way to slide, but it's something like that,
It's a kind of like a pump,
yeah.
and once it's pumped up, the only way to get it unpumped is fire. So.
So, I think this language addresses the house issue. I do need to check with the department about what they were referencing 4705. Maybe fix that, or maybe not. But then I can add it to 231 as you see fit.
Okay, any questions or other concerns? Comments? It sounds like this is something that we would like to incorporate. Unless there's objections. Yeah.
And I spoke to those people in your office,
Yes,
they don't have a problem with it.
that's
So, and
fabulous.
that's fine. but-
Yeah, so we'll try to have them in and get them on the record on that. I think that'll be helpful. And fabulous, great.
And I don't think you've asked for any other thing.
That is correct.
There was an email this morning. Regarding language that the agency is looking for concerning. The agency as a whole, concerning changes at the federal level. It was thought that that was in H 397 in GovOps, but it's not in H 397.
Okay. So we could put that in here, so just to,
I can provide context if you would like.
yeah, that would be great.
So many of Vermont's either statutes or rules have incorporated by reference federal requirements. For example, the federal drinking water standards are incorporated by reference in the ANR Safe Drinking Water Public Water Supply Rule. So instead of publishing, 200 pages of standards, you just incorporate by reference those rules and those standards. There are concerns that the federal government the administration is going to use what's called the good cause clause of the Administrative Procedure Act to repeal many of those rules. And if those rules are repealed, then Vermont's rules or statutes, when they have that incorporated by reference language, would be ineffective. So the proposal from the Agency of Natural Resources to have language that would provide that the version of the statute or rule that's incorporated by reference when it was last adopted prior to its repeal would still be good law in Vermont. Until it was amended or repealed or by you or by the agency in rulemaking. So it really is to prevent programs in the state from breaking down. Or being subject to challenge or being subject to non-compliance by a person to say it's not part of the law.
So,
Yeah.
so we're freezing them time essentially through that.
Yes, Ben.
Is this, are you proposing to put it in this bill, or is that
So-
more 319?
Well, so this is something that we have just emailed about and had not.
Had to discuss where.
Yeah.
Oh, I
That's where
see.
to put it.
And is it, if you would essentially draft the full rule as statute in Vermont statute, the current federal rules? Is that what?
No, what you would, it's, there's.
So I'm assuming that's long.
Oh gosh, no.
Yeah. Like lot.
So,
There is actual precedent out there that when you cite a rule or a statute, it does freeze it in time, but there's also conflicting precedent out there. And what we're trying to do, what the agency is proposing to do, is to focus on that precedent that freezes that in time. So even if the federal government repeals, it's still frozen in time as that law when.
But you have to make it explicit that says
Sure,
this
right.
is the rule we're freezing.
Yes,
Got it, I see.
but it's
Should
not,
we just do that with everything?
well, that's what this language is gonna do. It's gonna say whenever there is a rule or statute that's incorporated by reference and it's repealed. In order to maintain the program, it's going to.
But across not just water rules, but any federal statute that we reference and.
That will be up to you. It can be limited to the agency, it could be executive branch wide.
That's tough, because there's so many things. So many things, Michael, in the federal law.
I wouldn't even suppose how like AHS program
Exactly,
or
yeah,
or, SNAP. How that will be affected if any of these rules are repealed at the federal level.
so,
Or FEMA, they've already started repealing. And, Arkansas is not getting any help from the tornadoes, and so like, that's gonna be the things like that.
so I think if it was beyond the scope of our jurisdiction, that would probably be too much. I mean, to be fair, I think it would probably be appropriate to do at a broader level than what applies to our jurisdiction. And so I think this is a conversation that, if it was broader, this is probably a conversation to have with GovOps. But this, for our purposes, I think we need to protect the rules that we have in our jurisdiction. So this, if we were to, until we have any indication that something broader is going to happen, if we can include something to that effect, but limited to our the jurisdiction that we cover. And then, do you have any opinions as to whether it would be a better fit in 231 or 319?
Well, 231 is very specific to the Department of Fish and Wildlife.
Yeah.
For 319 has programs or has amendments related to the agency as a whole, so.
Yeah, my sense is that it would be better in 319. But thank you for raising it. Any objections, or yes, go ahead.
No,
Yeah.
but, we talked about this in the context of repeal. What about gutting, but it's still there? Are we actually trying to freeze in time?
I mean, if the law is still there, but the department that implements it is gone, The law is still good for purposes of Vermont because of the incorporation by reference.
I was thinking more about, yeah, there's still the underlying law done. And we'll stop with that.
So that's why you have to look at this language. And
Okay,
sorry,
okay.
It freezes it at.
It freezes it, okay, that's,
Yeah.
okay, good.
What it says right now.
And so just as another kind of example of that, if like say the drinking water standards are degraded so that more polluted water is acceptable, that we would still hold to the prior, the frozen standard, yeah.
I mean, what about also the Clean Water Act, just in general,
That's part of the concern as well.
Yeah.
There are a lot of very technical parts of the Clean Water Act that thankfully you never have to deal with because they've been in place at the federal level and accepted for so long. For example, the what are called water quality based effluent limitations, the QBELs. And the QBELs are very technical and specific, and if those were repealed, I don't even know when we would be able to adopt them by rule in the state. So that's why you would want something like this to freeze QBELs or HAPs under the Clean Air Act, hazardous air pollution standards, or the drinking water standards, or the regular hazardous waste standards. I mean, the list is gonna be
It seems like we would
long.
want to make it as broad as we all could agree
Yeah.
on, because it. I think all of that is probably at risk right now. Not just the clean water drinking standard.
Oh, agreed, yes. So, this may not be a question for you, but it makes me wonder, I mean, just the volume of federal law that exists that could potentially be at risk. If websites start to disappear with that information, this is really, I think, a question for the department, but do we have any records of what those laws are?
So if it's in rule, and it's incorporated by reference, the administrative agency is supposed to keep a paper copy of what is incorporated by reference for access by persons who don't have electronic access.
Mhm.
They should have a paper copy of everything that they've incorporated by reference. Whether they do or not, that's a question to be.
That just feels like a thing worth asking about.
We should start printing off those websites.
But that's a lot of paper.
As
No, well spent, but still.
Yeah. Sacrifice a tree.
Or like a lot of space, taking up a lot of space. We don't.
any statute that's incorporated by reference, we have a library. And our library has everything going back
Okay,
over 100 years.
Okay.
We don't have the CFR, we don't have paper copies of the CFR, it's expensive and it's space consuming.
yes. Yes, that makes sense. Okay. And yet, if we were to do this at the level that is probably necessary for, beyond our jurisdiction, then that could be something that would be of interest to every department.
I think it is of interest to every department, the nuances of other agencies, I don't know,
Yeah.
like.
I hope other communities are having this conversation, health and welfare.
Yeah.
Potentially workable.
Mhm. Yeah, okay, so, thank you, so we're gonna incorporate this language. With your, smoothing it out, into 231.
Right.
We'll incorporate some version of the language that we were just discussing into 319. But tailored to what our jurisdiction is.
So-
Yeah, and then if it becomes redundant because GovOps does something more broad, amazing, that's fine, so.
Okay.
Thank you so much. Okay, and we are a little ahead of schedule, which is great. So so we're gonna be going back to the issue of appeals and housing. With 479, starting at 10. So we have a little bit of time here.
We actually haven't gone, we're going over the. Alan's coming walk through. and-
Yeah.
Oh,
Yeah. And
Okay.
do you know if we have Rutland Holly?
Friday,
Okay. All right, well, hopefully
Yeah.
we'll see you. Okay, so we have a little break until 11. I mean, 10.
Yeah.
10. Okay, all right, so this is Senate Natural Resources and Energy, coming back from a break and. We're looking at, Bill H 479, which is right now in Senate Economic Development. But I'm anticipating that we are gonna, have possession here sometime in the near future, so. Just getting a head start on, the portions that would be relevant to us, in this committee. With that, I'm gonna. Well, actually, before we do that, I just wanna check with Jude,
I
we,
still haven't heard, I
haven't
just
heard.
texted his admin, but she didn't get back.
okay, so if Reverend Holly comes in, great, we'll hear from him, but if not, we'll just jump in right now. Now, welcome.
Great. On behalf of the Office of Legislative Counsel, so the section of H 479 that I drafted are sections 8 through 12. And section 12 is the land review board appeal report. So just as a flag, last year and so all this language starts on page 18. I figured I'd sort of work a little backwards through the simple part. So section 12 is on page 22 and 23. And last year in Act 181, there was this report requested of the new board that oversees Act 250, the Land Use Review Board, asking them to look at a number of different angles on Act 250 appeals. And that report is currently due next January 15, 2026. Both the House and Senate committee are interested in moving the deadline of that report up so that they could have you all can have the information sooner to potentially lead into a bill, as people are interested in hearing what their recommendations for changing Act 250 appeals would be. So it moves up the date, and then again, it asks them to include what resources the board would need for changes. And this language was already passed by the Senate in S 127, the Senate's housing bill. So it's the same. And then also just moving backwards, section 11 is not about appeals, but about zoning bylaws. And it's adding new language to 24 VSA 4441, this is on page 22 of the bill. And it says, notwithstanding this section and any other law to the contrary, for bylaw amendments that are required to comply with amendments to this chapter, no hearings are required to be held on the bylaw amendments. So over the last few years, the legislature has made a number of amendments to this chapter about what municipalities need to include in their bylaws. Municipalities to accomplish this then have to go through the bylaw update process, which does include at least one public hearing on proposed bylaws. Municipalities are interested in not having to do hearings on bylaw updates that are required. I would flag that there's, I have some minor concerns with this section. As we talked about earlier, and we'll talk about again in a minute, one of the requirements in order to appeal something is to have participated in the hearing on the issue. This is eliminating one of the hearing requirements. I do think potentially if no hearing was held at all, someone couldn't have participated, so the courts would recognize that as an issue that would have prevented someone from being able to appeal, and I think they would find that would be manifest injustice and would potentially allow an appeal to go forward. Also, VNRC is of the position that that isn't an issue because these are non-regulatory hearings, they're public hearings, and the participatory requirement is for regulatory hearings. So perhaps that is not an issue, but I do want to flag it as something you should consider perhaps.
What did you call it? Manifest
Injustice.
injustice. That is is that like a term of art?
Yeah, so that's a legal term. It is in the environmental court statutes, and it is in the other civil division court statutes as well. It is broadly considered sort of one of the escape hatches, but it is specifically outlined in the environmental division's procedure where someone's seeking an appeal if they don't have party status, they can claim that there's been manifest injustice that prevented them. And some of the issues like that are, there was no notice to me, there was a defect, like the municipality had deceptive notice, I couldn't have known there was a hearing. The hearing was held in secret, or I wasn't, so that is when manifest injustice, the court could find that not allowing someone to appeal would be manifest injustice because there was no physical way for them to have participated. And so, yes, that's a pretty common term of art in the legal world.
Okay.
Yep.
That's good to know. What?
Legal art.
Legal art.
So then sections 8, 9, and 10 of this bill are looking at municipal permit appeals and changing both the standing and attempting a little bit at getting at the standard. So sections 8, 9, and 10 work together to do something, and I realize that it can be a little bit confusing, but all 3 sections read together accomplish the change who has the ability to appeal municipal permits. So section 8 is amending language in the environmental courts statutes. It's amending the definition of person aggrieved. So for those of you who are here for my talk at 9 AM, I described that for Act 250 permit appeals, as well as A&R permit appeals, the court recognizes a person aggrieved as who has the ability to appeal. And the definition is here, so it's a person who alleges an injury to a particularized interest protected by the provisions of law listed in 8503. Attributable to an, so I'll stop there for a second. In 8503, there's literally a very long list of statutes that are the statutes that the court has jurisdiction over. Among those are many different A&R permitting statutes, as well as Act 250 and the municipal zoning chapter. And so it goes on to say, attributable to a decision by a district coordinator, a district commission, the secretary of A&R, or the environmental division, but it's adding an appropriate municipal panel. And that is because currently, as I also mentioned, for municipal permits, there's been a different standard for who has the ability to appeal. It's been interested persons, not persons aggrieved. And so this bill is seeking to merge those things so that they're, for municipal appeals, we're leaving interested persons, but adding that persons aggrieved will have the ability to appeal. And so the difference here is that person aggrieved requires an injury to a particularized interest.
Are you you're adding persons, we, not you, the bill is adding persons aggrieved, not replacing interested persons with persons aggrieved, or is it
Yes,
the latter?
no, it's the former. And so you will see that in section 9 further down on this page. But what I'm doing is a little bit what the bill is doing is a little bit complicated because it's keeping part of the definition of interested person.
Okay.
And replacing the other parts with person aggrieved, which is a higher bar
Yeah.
than what is currently in the definition of interested person. So section 9 then adds the definition of, that adds reference to person aggrieved. So within 30 days of an after decision, an interested person or a person aggrieved who has participated as defined in the municipal regulatory proceeding may appeal to the environmental division an after decision made under this chapter. So we're gonna look at the definition of person aggrieved or interested person next, but it's saying either an interested person or a person aggrieved. And so, yes. So we
Listed in that. An interested person or a person.
yeah, because they have separate definitions. And so I'm gonna skip page 19 for the moment and jump to keep on this thought to page 21. So in section 10, this is the rest of it. And so this is complicated because the the municipal permit appeal process is spread over multiple sections of law, and so I had to, it's a complicated situation at play here, but so the definition of interested person. It states who currently under the law can appeal, and so. Number one on page 21 is the person owning title to the property or the municipality or the solid waste district. Number two is the municipality that has a plan or bylaw at issue under appeal. 3 and 4, I'll come back to it. Number 5 is the agency or subdivision of the state or the agency of commerce and community development. So it's leaving intact 1, 2, and 3, which is the person owning property at issue, a municipality or a state agency. And those will be considered interested persons for purposes of this.
Question.
Go ahead. And then it is striking 3 and 4, which I'll talk about more in a moment.
Okay. I think I need to understand 1 a little better, because because it says. A person running title to the property, that seems obvious to me, but they might also be the person who is. Applying for, the permit. Or municipality or solid waste managers is empowered to condemn it, so, or an interest in it. Affecting by a bylaw, how is number 1 different from number 2 in that? So maybe number 1 includes municipality. I guess it's starting to. I think I'm starting to understand how 1 and 2 are different. Because 1 is like if there's a municipality who has an interest in the property, right? Like they have a lien or they have they're potentially gonna condemn the property. They have some interest in it. 2. Was a plan or bylaw an issue with an appeal? So if municipality has a bylaw, they could also be a party, or no, they could be an interested person.
Yeah, I'm not really sure why that distinction is made in statute. I don't know why.
Why those 2 things are separate, because it does,
Yeah.
it's a. It does feel a little odd that. I guess I can see it, 1 being like. Who either owns it or has liens on it. 2 being like, well, we have rules about this property, and that's sort of a separate idea, I suppose. Okay, thank you, I just needed to like digest that before I can go. So we're eliminating 3 and 4.
So the proposal is to leave 1, 2, and 5 as interested persons who will still have the ability to appeal. But getting rid of 3 and 4, which are the types of interested person that the legislature has reviewed multiple times in the last few years. So number 3 is a person owning or occupying property in the immediate neighborhood of a property that is the subject of any decision or act taken under this chapter, who can demonstrate a physical or environmental impact on the person's interest under the criteria reviewed, and who alleges that the decision or act, if confirmed, will not be in accord with the policies, purposes, or terms of the plan or bylaw of that municipality. So a person in the immediate neighborhood of the property who can demonstrate a physical or environmental impact. And so this is different than a particularized interest. It first does have that location requirement. And then demonstrate a physical or environmental impact is a less high bar than particularized interest to particularized interest an injury to a particularized interest protected by the chapter. So so interested person has number 3 has different requirements than what is required for an aggrieved person. There's no location requirement for a aggrieved person, just that they be able to allege an injury. So that is a change, because 3 is very specific to the immediate neighborhood. This could be a person located outside of that neighborhood or potentially in the next town. But they are also striking number 4. So number 4 is the any 20 persons. For a long time, it was any 10 persons, but last year the legislature increased it, so any 20 persons who may be any combination of voters, residents, or real property owners within a municipality, listed in subdivision 2 of this subsection. Who by signing a petition to the appropriate municipal panel of a municipality, the plan or bylaw at issue, which is at issue, and any appeal brought under this title, allege any relief requested by a person under this title, if granted, will not be in accordance with policies, purposes, or terms of the plan or bylaw of that municipality. The petition to the appropriate municipal panel must designate one person to serve as representative of the petitioners regarding all matters related to the appeal for purposes of that subdivision. An appeal shall not include the character of the area affected if the project has a residential component that includes affordable housing. So there is no requirement, we're on page 21.
Alright, that's it.
Yep, interested person. Number 4, any 20 persons. So, any 20 persons who live in the town do not have to allege any specific injury to either the group or individuals.
And this is for all types of development that is required, that's subject to, and this is for municipal.
Yep.
No.
Yep.
Not Act 250 or also not Act 250?
Not Act 250. Act 250 just uses persons agreed.
Okay,
Agreed person. Yep.
okay. And this is for, sorry, missed your talk.
That's okay.
This is for anytime there's going to be a change in the municipal bylaws? Or is it for any kind of project that is subject to the municipal bylaws?
It's both.
It's both, okay.
And so after I leave here, Senate Economic Development is going to look at a tweak to this to allow this to remain an option for appeals of the bylaw or plan, but eliminate it for permit appeals.
Okay.
Yes, because this system for interested person is for generally a municipality is adopting their plan, their bylaw, and then any permits adopted under it. So there are sort of 2 different appeal types.
Yeah,
Yeah,
I mean, when you're coming up with a plan, you should be able to have your day to tell your municipality, I don't like this plan, like, that's kind of part of the democratic process. Like, when there's a town plan, when there's a municipal plan, till it becomes the actual official plan, people should be able to. And this would say that couldn't do that anymore.
the interested person who are allowed to
Appeal a plan,
Not
not that
really.
it becomes a plan.
yes, appeal it.
It's, okay,
Yes.
okay.
So the language, so this language. Is not about it, like, does it differentiate between appeals of the plan or just appeals of permits?
So. I
What is
have
this?
spent the last 5 days contemplating this because I think it's not clear. I think some of the language in here is intended to distinguish who can appeal a permit versus a bylaw, but honestly, I think the courts have allowed, like, reading the report suggests that it be about a plan or a bylaw, but clearly it has been used by the court as a category for people to appeal permits. And so I think some of the language was intended to make the distinction, but it hasn't worked.
Okay, that,
I don't think so, and if anyone wants to contradict me, I mean, this is why we've been talking about these sections.
yeah. It does seem like that would be a good distinction to make, or at least add clarity about that. And so the language that economic development may have some distinction.
Yes.
Okay.
trying to
we'll
clarify that, yes.
put a pin in that, and see what economic development comes up with. But here and there, yes.
At the very least, that's where. Because people absolutely have to go to appeal the option of bylaw and 20 people. You recall that the language at the top of page 22. Last sentence was added in Section 100 a couple of years ago,
Yes.
when we made that switch.
Well, what the home entries.
Yeah,
Yeah.
yeah.
Mhm.
To sort of say that if it's a residential development, you can't appeal on character of the area if it's zoned for residential development. We added that 2 years ago. And then the thing that's the question for the committee here ultimately is, you know, your town is this block,
Mhm.
and in a way, and this is just the tension I have to figure out here. You can make a case that you know, the 20 people have historically, or 10 have historically been able to appeal on the basis that the permit issue did not conform to the bylaw, violates the bylaw, and to make the case that that affects everybody in the community. Whether you're, and that was why we always had, the 20 was a compromise moving in the other direction of a little bit harder, but there is, you know, how do you really define harm if it's something that there's a few within that community, and that's where you spend 95% of your time, as we tend to do. You know, what happens over here actually does really matter to you.
Mhm.
So especially if you're saying, if there's a course being set that you believe violates the bylaw. So that's the tension here. And the tension is on the other side of it. Or this opinion, it's driving me crazy. But there's a real policy, there's a lot of policy issue here.
Yeah.
At the very least, we can, the Senator Hardy is suggesting that this absolutely has to be applied to the adoption, and then we have a discussion to have about whether we're in our own, especially as it relates to people's ability to be the project.
Mhm. Okay, good, sorry.
Yeah, and number one, there's so many commas in there that I'm trying to figure out, where I guess there are only 3, but there. No, there are only 2, sorry, but, okay, thank you, Alan, yes, you're right, okay. A person owning title to a property. So let's just pick that person. Affected by a bylaw, so the property is affected by the bylaw, not the person. Okay. And then who alleges that the bylaw imposes on the property unreasonable or inappropriate restrictions. What about somebody who owns a property next to the property that is being impacted by the bylaw? Would they be able to, that's number 3.
Yep.
Okay, so this one is just for the person, the actual property owner of the property that's being impacted, saying, oh, you can't. Just making this up, because you can't put that porch on that property because that is against the municipal code or whatever. So only that property owner could, under number 1. But under number 2, what if the porch that person is trying to put on their property, like, is on the side of my property and leads, you know, and they have to cut down a tree that goes into my property or something. I don't know, I'm making stuff, I'm totally new to this, so. But would that hurt the neighbor not have standing anymore if we got rid of 3?
So that is why aggrieved person.
Oh, aggrieved,
Because
because
they
they
would
have
have
to
an
be like,
injury.
you're taking my tree.
Yes.
I'm aggrieved, okay.
Yeah.
I see, okay.
It also would allow, the example House General was using, if a person not in the immediate neighborhood, but down the street farther. Runoff from the new project was running up to their property, they were technically outside of the immediate neighborhood, but they still have an injury. That would give them the ability to appeal, where previously they did not have that ability.
If by adding aggrieved.
Yeah.
Okay, and what about sort of increased traffic in the neighborhood because of a project, is that an agreement?
So there's actually a lot of case law under Act 250 about at what point traffic becomes an injury.
Uh-huh,
And so, yes, it can be, yes. But you have to, there's a few different factors for traffic that I'm gonna probably get wrong, but, it's not just general traffic that would be felt by all members of the community, you have to demonstrate that it's specifically impacting the way you get home every day. Your only route home now has more traffic, that's sort of an example, but if traffic overall in town is going up, that's slightly different. And maybe not particularized interest.
what about traffic that's idling in front of your house as they wait to get to the Amazon? Just a little delivery center, and the fumes are,
Or the noise from the truck brakes.
yeah, exactly.
Yes, potentially, yeah.
Hmm.
So that actually does raise another issue that Senate Economic Development is contemplating, and I will flag for you. Particularized to what? So person aggrieved currently is particularized interest protected by the provisions of law. And so currently on that list is Act 250 that has a defined set of criteria that it's protecting. And it has a number of ANR statutes that have permits associated with them. And so it's pretty specific to like stormwater runoff or wastewater. Chapter 117 is 220 pages. It's a long chapter and discusses a wide variety of topics. And so I do think there has been testimony, and there probably will be more today, that some attorneys think that it doesn't need to be more specific than that. I'm slightly concerned that it should be more specific. And so I'm the new draft that will be presented will be specific to the language in 4302C, which is the purpose section of chapter 117, which even in of itself is a long list of things that chapter 117 is seeking to protect. And so Senate Economic Development, Senator Clarkson is proposing that as a potential clarification. I don't know, there will be some testimony from other practicing attorneys later today. I'm just raising that as a flag because I am not a practitioner of litigation, and so it seems a little bit vague to me about what traffic seems fairly obvious. Municipal zoning permits can regulate a lot of different aspects of a project. A lot of them are similar to what Act 250 looks at, but the municipality has pretty broad authority. So just may want to consider how specific you want to be.
Well, and so on that point, and when we look at the language that was deleted in 4, it's on page 22, it's the last sentence, that's
Oh, yeah.
been deleted. The purposes of this subdivision, an appeal shall not include the character or area affected if the project is a residential component that includes affordable housing. Right, like that was us trying to narrow the scope of what could be the grounds for an appeal. And in a way that without saying that again, like if that language goes away, then that restriction goes away as a basis for an appeal if we just go to particularized interest in general. Is that accurate?
Yeah.
So, I mean, one potential, I'm just flagging this as an idea, is that we might want to take that sentence and put it in page 18, you know, the particularized interest paragraph to say, by the way, it can't include this for this in these conditions. It can't, you know, character the area. Just as a thought, something that I'm interested.
Do you have like visuals on this?
You made tears of.
No. It seemed like that would have been something you would have made in past years, like you were trying to explain this to.
So, for record, what I did was I wrote it out.
You're right.
What I did, this is complicated, and so I hear you, and so what I did was I wrote out for myself step by step of the appeal sections in the process, which I'm not going to give to you.
Oh, but you told me you have it.
But I've been trying to figure, so like there is technically a section by section where I attempted to summarize what I said, because reading it across 3 sections, I know is hard.
Yeah. I fear of unintended consequences for any change that we make. And I don't understand it enough to know what those might be. You've worked in this area a lot, so I would think that. I mean, how do you feel about these changes?
So. There's a whole level of sort of philosophical underpinning to this or approach. One of the things that happens, and this is from the perspective of the developer. What happens is we go through these, we adopt bylaws and plans, and people in town don't necessarily pay a lot of attention as that's happening. And then somebody puts in an application for something that they can actually, may well conform, and everybody goes, no, not that, you don't want that. And so what we get is after the fact planning, trying to use the permitting process to do after the fact planning. And that drives people crazy. So that's on the one side of this. And on the other, sometimes they're right. The opponents. And so what we began to head toward with this one sentence, it's just a little precursor, is really trying to do this, not just with meat acts, taking away the ability to appeal, but because I think 20 people do have interest, my own view, but I also can see really figuring out when and how. There's a lot more of that language to figure out. I think we do. I'm actually also, so I'll say they have right to appeal. I'm also in favor of limiting it and really forcing the discussion and debate to the time that you're adopting the bylaw and the plan. You better pay attention because it's going to mean something. You don't get to use the appeal process as a means to do after the fact plan. We haven't paid attention in the first place.
Yeah.
So that's the quandary. And all I can say about it is we got one sentence that we did, and we could begin that as a precursor or to beginning that process, saying you better pay attention in the first instance.
That one sentence being which one?
Housing.
Okay.
So I'm of 2 minds of it in that for a good reason, because there are those who, I think developers can get abused by the process. And so I get it, and I'm sympathetic for that. And yet doing things with the meat acts always makes me nervous.
Yeah. And is there a way that we could make the planning process more, make people pay attention to it more? I don't know. I mean, it's hard because you're absolutely right. When the planning commission meets in towns to go over bylaws and, nobody shows up. Yeah, nobody comes, and then the people who do come actually are often people who know they're gonna develop something, and so the developers come and not the people who might be directly impacted on the other end, so.
It's so abstracted that way.
Yeah, and it is an abstract, until you have some proposal in front of you, it doesn't make any sense. Yeah.
And in so exceptions, I had an incident that, I kind of support striking that language because we had a change of use in my district. And it was going from industrial to commercial, which you think would be okay. But there were basically 4 people that knew 16 people who got petitioning them. And they tied this thing up for 3 years, ended up in environmental court, and the municipality had supported it, and ended up winning. So, if you're an aggrieved person, you should have a say. But if one of the individuals who was aggrieved by this had lived next to the industrial, And commercial was not gonna be anywhere near as, much noise or traffic. Or, 3 shifts, so anyway, it's gonna be tough, you're not gonna be able to please everybody, anyway, for sure, but. I can think of a nuisance where that would apply and be good.
So I did wanna add, I think Representative Mahali, if you hear him, I wanna add a couple things I think he would have said. Which is, they did take testimony, particularly from the court, so Judge Snre has testified on this a couple of times. So as I sort of mentioned, the list of people who have standing for municipal permits is very different than for other types of permits. There's constitutional standing generally, which does require an injury. However, and so that's what the courts always look like. Do you have an actual injury that this court could resolve by looking at this appeal? And that's the baseline, but the Supreme Court has also said that states generally have the ability to expand and include people who are not necessarily injured, which is why this municipal decision, this municipal list is different than other types of permits. And so this is different than how many other statutes currently work with 20 people who may not have actually suffered an injury. And so there has been very recent case law at the environmental court where, for the first time, the court looked at the group of people and said, 18 of you don't actually have an injury. So I will grant standing to just the 2. But that is not official precedent. I think you are familiar with that case. It's the Montpelier hotel case. And so that was the first time, though, that the court had recognized that perhaps they should impose an injury requirement on this 20 persons standard. And so there is question if that court did not, that decision was not appealed. And then so the Vermont Supreme Court did not look at whether or not that was a proper decision. And so Judge Snre was one of the people who suggested some kind of compromise here that looked like a traditional injury standard. And so I think they have also been confused by this lack of injury requirement. They obviously can't take a position on that until a case is before them, but this is unusual. And so House General was looking at, okay, what is a compromise? And so if you look at striking number 3, okay, you're getting rid of a locational requirement, and so you are potentially expanding who could appeal. But also by getting rid of 4 with it, you're getting rid of the people who don't actually have a demonstrable injury. So they were looking at a balance there. Whether or not that is the balance you all are looking for, or you want to add additional clarification is the question for you.
If I recall, they issued a document that spelled that out, and I'm wondering if we can dig that up, because it spoke to
Yes.
this, actually this very issue about, if you have 20, at the time it was 10,
Yeah.
but if you have a group of people, is there an understanding that they must have been injured somehow? Is that part of the assumption? And anyway, if the letter, if I recall, speaks directly to that.
Right, and in other types of cases, not municipal, there's something called organizational standing. Where like particularly environmental groups take advantage of it, where they say, we have an organization, but we have an injury because our organization is nature lovers who hike. And so this trail and this scenic view shed is going to be impacted by this project. That is an injury to us. And so these any 20 persons don't even have to, by this statute, have that, which is different.
Well, I mean, their injury, it's not stated this way, but the injury is the bylaw is being violated, setting bad precedent, and therefore that's bad. That's the injury.
That it doesn't conform
Yeah,
with the.
and therefore
With
it's
the
setting
plan.
bad precedent, and you'll get that resolved.
Mhm,
It will impact them, even though to some degree it doesn't, because we all impacted by whatever
mhm.
happens, but. So I'm of 2 months,
Yeah.
but I'm of 2 months about this, there's a.
Yeah.
Yeah, isn't the organizations that sue on behalf They're technically doing it on behalf of their members, aren't they, like, they have to have members organizations, yeah, that's.
Yep.
So it couldn't be the organization itself, it's, we're saying that our members have a, you know, who hike and like birds or whatever, are injured by it.
Yes, but they're generally identified as an organization as a single person, like fictional person. That is made up of members who have this particularized interest. And again, it can't be general, that's why a lot of such groups who have like mission statements and particular
Yeah,
things that they focus on, so they can identify that as their particular interest.
right. And would that eliminate their ability? No, okay.
So, there are two other small parts of this amendment that I do just wanna flag for you, so, not on this topic, they're on a different topic. So on page 19, so there's this language. Not on standing, but on standard of review. And so, the administration had proposed language about, clear and substantial departure from a bylaw. But the language was a bit abstract and it was unclear to me if it was asking to look at the standing component of who. Or the standard of review, which is how the court reviews the case. And so House General spent time looking at that language and different configurations of it, and this is what they came up with, which is a deviation on that. So on page 19, de novo hearing, the environmental division, applying the substantive standards that were applicable before the tribunal appealed from, shall hold a de novo hearing on those issues that have been appealed. And so de novo hearing is hearing the case anew. The environmental division hears all the factual evidence and the legal evidence, and they do not take any assumptions from what happened below. There are two exceptions to that in the statute currently. Those are appeals that are on the record under municipal appeals, and then decisions by the Commissioner of Forest Parks and Rec. And so it's leaving that, but it's adding this new language. So for a municipal land use permit application for a housing development, if the appeal is of a denial, the environmental division shall determine if the application is consistent with the municipal bylaw or land use regulation that directly affects the property. Or if the appeal is of an approval, if the application is inconsistent with the bylaw or land use regulation that directly affects the property. So I don't think this language actually adds anything, because that is. The environmental division is supposed to look at the substantive standard that was applied. And this is a restatement of the standard that the municipal panel would have used. They would have looked at. Is the permit consistent with the bylaw, or is it inconsistent with the bylaw? So. I don't know why I don't think this is adding really anything. But they did want to add some language here, making it clear, I guess, that's what happens when a housing development appeal.
It seems to me that. When we add language like this to the statute, the question becomes, if this language is not there, what does it mean? Like in other cases. So I would be reluctant to add something doubling down on an already done thing. Because then in other cases where you don't double down, the court might be like, why didn't they double down over here or double down here? And I don't have a counter argument. I mean, I don't have another example for that, but I think in general. The absence of something makes the courts confused when there's the presence of something in another area.
Yes, the case law says, when something is added to statute, the court has to assume it was added advisedly.
Yes.
And so that there was a specific reason why something was added.
And 7 years of being on judicial retention, I've heard judges say this, and so it's really. If we're gonna add something, we have to have a reason for adding it. And then if we don't add something somewhere else, the same thing, we have to have a reason for not doing that.
Yeah, I do see it how it's a restatement of. The consistency with the bylaws. But it is captured elsewhere. Okay.
So the only other thing in here is on page 20. So. It added this language in subdivision 5. So last year subdivision 4 was added, which is that the environmental division shall have a goal to issue. A municipal appeal decision within 90 days following the close of the hearing. But it's also adding this language that except for cases the court considers of greater importance. Appeals of an appropriate municipal panel decision under 24 VSA chapter 117, the bylaw and permit chapter. Involving housing development, take precedence on the docket over other cases and shall be assigned for hearing and trial. Or for argument accordingly. This is an attempt to prioritize housing, municipal housing development appeals at the environmental division. So this language is actually identical to language that's been added for public records cases and campaign finance language. So we know it has been added in the past, asking the court to prioritize. Languages like this can raise a flag of separation of powers, but you have used this language in the past, and part of it is because it's kind of soft, right? It's asking them to prioritize, but it also says except for cases that the court considers of greater importance, and it also says schedule assigned for hearing accordingly. It doesn't spell out any specific timelines for how the court would actually do this, and so the court has not taken issue with the case with that language in other statutes where it has been adopted. So I don't think there's a huge risk.
Did zoning weigh in on this? And he doesn't like it, right?
I think he did say it provides the court with enough flexibility that they will be setting their dockets and that they do prioritize and try to move cases already as quickly as possible.
Okay. Yes.
I would note that this could be prioritized, sending homes to the ski area.
Yeah.
Yes, and I think he,
Housing, yeah.
right. I think he raised something like that of, you prioritize all types of housing. It does have other consequences, so, but it is a flexible standard that doesn't have any kind of timeline, so I don't think there's a constitutional risk with it.
Okay. Interesting.
So this is complicated language because the language that currently exists in chapter 117 establishing the appeals process is complicated. It's spread across, I thought it was just 3 statutes, but it's actually kind of across 4 statutes. And so, I mean, we could rewrite whole parts of it to make it even more clear if you have the time. But this is the proposal that came out of the House, and it is a little bit complicated. But I hope I explained it clearly enough.
Sounds like a more comprehensive rewrite is something you might be interested in.
I mean,
You gotta do the energy statutes first, they're very worse.
Well, listen. So anyway, other thoughts on this?
all of this is just municipal appeals, mostly about housing, but not entirely about housing. No Act 250 stuff in this. The only Act 250 adjacent thing is that LURB report. The rest of it is yes.
Just to be clear, that you said mostly about housing, the appeal section is across the board.
Yes.
Yeah, that's why I'm thinking unintended consequences and trying to play that out in my mind. Yeah.
So just to be clear, so this reference for 24 VSA chapter 117, so it was the bylaw and permit chapter, so inherently a zoning, like a municipal chapter.
Yeah, so this, it's regional and municipal planning and zoning, and so it does incorporate regional planning, town planning, and then town implementation of the planning, which is permitting, and so it's a pretty broad scope, but it is all municipal or regional planning.
What committees did this in the House?
So, general started with it, but, House Environment spent time on it and actually, were the ones that proposed the agreed person standard. And so they worked with House General on that, and so House Environment voted without unanimously.
Okay. That is good to know. Okay, any other thoughts or questions or comments at this point? Okay, all right, well, so this is something we're gonna revisit, especially as Senate Economic Development has some further things to say about it. So it's good to have this background for now. All right, thank you so much. Okay, and again, running a little bit early, our next person is at 11. We're actually getting hear from Judge Zoning
On a different.
on a different bill, but if he's well, we'll see if he has any flexibility to speak to other things as well. All right, so we're gonna take a break until 11.
Yeah.
There's two sites.
I'll give you this, I've got,
Was there somebody else?
I've got a back license. I've got a contract, I'm sure, but I want
Okay, all right, this is Senate Natural Resources and Energy, and we are coming back from a break. And we are switching gears, talking now back about H 231, about the Fish and Wildlife Department. And while we were just talking about housing and appeals, which does pertain to Judge Zonet's area, we're gonna hold off on questions about that for another time and just focus for now on H 231. So welcome.
So thank you for having me. I'm Snre, Chief Superior Judge. This will be much shorter than it would be for 479.
Fair enough.
So let me know when you'd like and I can come over and visit with you on that.
Great.
But as far as H 231, this is a technical correction bill. The bottom line is that for judiciary purposes, the statute makes it clear that the Judicial Bureau has jurisdiction of certain matters. And why, one would ask, would the Judicial Bureau not think it had jurisdiction over those matters? Because there were some statutory changes back in 2015 that mucked up the waters a little bit. And what happened was last year, it was noticed. I think it was our chief hearing officer, Judge Romeo, found it and recognized this. And one of the questions I have to say is, well, what happened in the interim? Why didn't this get noticed sooner? Well, that's because there was only 11 violations of the statute that would have fit within it during that time period, none of which went to a contested hearing. And so it never came up where that was noticed, but he did notice it. And so all this does is it says that any rules that are adopted under 10 VSA 1424, if there's a violation of those rules, the Judicial Bureau hears them. And this language, I would note, I did as part of the House when I testified, they had some different language and we added that to make it say violation of rules. And so that we're comfortable with that, and it will accomplish the goal to make sure that there's no question that the Judicial Bureau has jurisdiction.
Judge Zonai, do you have, I'm wondering if we can identify which part of the bill we're talking about?
It is section 6
Oh, section.
on page 6
Oh, yes.
of the version I'm looking at, the section 6. It adds in under 1102B19, violations of rules adopted under 10 VSA 1424 relating to the use of public lands.
Great.
Okay, perfect.
And I would, in section 5, the language that says for a fine under this chapter, I view that as clarifying,
Mhm,
make it clear that a fine is something that is potentially available.
mhm.
And so we have no issues with that.
Great. So for chapter 6, there were only 11 violations between 2015 and last year, and none of those were contested.
That's my understanding.
Okay,
yes.
great. Okay, any other questions for Judge Zonai? Okay,
Thank you.
wow, great, that very
Thanks for
quick.
stopping by.
Thank you, yeah, and we'll have you back another time.
Thank you.
Thank you.
Take care.
Okay, and so we have another break here until 11:30.
Wow.
So just cruising.
He's like one of the nicest people in the world.
Oh,
Right.
Trying to get off. Which is.
I mean, you just said that live.
I'm trying to.
Take it back.
Genuinely good person.
Yeah.
Not sure why.
Oh, yeah, it's like, it's not responding
Not
to,
respond.
like we can't.
I'll have
do
to
it.
just.
You came down to the website.